everybody. I'm very glad to introduce to you judge and professor, or professor and judge, I don't know which one you prefer, Guido Calabresi. He's one of the most renowned legal scholars around the world, and I'm not exaggerating in saying that. First of all, we start with the introduction with the things that we know best. I mean, the fact that Guido Calabresi sits on the IUC advisory board, and as far as I know, he has been one of the founding fathers of the IUC, since he has written down the very scheme of our curriculum and program. And so it's really one of the pillars of our institution. His name is very well known. As I said, he's connected to this famous line of thought in the legal and political domain known as economic analysis of law, and not law and economics. This is something on which Professor Calabresi is very interested in having this distinction. He studied law at Yale University, where he became dean of the law school. He published a wide series of books and articles, among which I will quote an article of 1961, Some Thoughts on Risk Distribution and the Law of Torts, in Yale Law Journal. In 1970, a very well-known book called The Cost of Accidents, a Legal and Economic Analysis, published by Yale University Press. And in 1972, a joint article with Douglas Melamed called Property Rules, Liability Rules, and Inalienability, One View of the Cathedral. And as far as I have understood, the two-day lecture will have some links with this text, with that article. He's also judge on the U.S. Court of Appeals for the Second Circuit in the state of New York. And yesterday he gave a wonderful speech at the University of Turin dealing with federalism, which I found really striking and fascinating. And so today he will give you a lecture on the centrality of the liability rule, correcting a misapprehension. And so this is why it will deal with the previous article. So I give him the floor, and please enjoy.
Hi. I'm going to talk a little bit about tort law, civil responsibility, and about this view of the cathedral and something that was wrong with it, and the relationship of the view of torts and law that has been associated with me and others, and some revisionists that are important now, and try to put that in a broader framework of different approaches to legal structures. So that's what I will be talking about. But I'm also here for your disposal. I'm a judge on what may be, after the Supreme Court of the United States, the most important court in the United States. It's the Federal Court of Appeals, which covers New York and various other states, and because it covers those, is extremely important in any number of issues. And as a judge, I'm a judge of everything. I'm a constitutional judge, I'm a commercial judge, I'm a torts judge, I'm a bankruptcy judge, I'm a criminal law judge. I cover, the only thing we do not cover is appeals in patent cases. But in copyright and trademark cases, you name it, I know it. And the role of a judge in the United States, a judge like me, is a very interesting and complicated one. So, at the end of my talk today, and maybe tomorrow, where I'll be talking about more theory of law and economics, but I want to correct you. I believe in law and economics, not in economic analysis of law. It's the other way, and I'll have something to say about that tomorrow. After I've finished, I'm very happy to answer questions about all of those things. Yesterday I talked at the new campus about federalism, because it is one of the things that I'm much involved in as a judge and as a scholar, so I can talk about that, but also other things like what a judge does when faced with law that is, in his or her view, morally wrong. What I do, if I have a case that involves the death penalty, which I am personally and morally very much opposed to. What does a judge do in that situation? In some way, the role of the judge as against the role of an academic in a society. I say these because, when I'm finished giving my talk, it's your time, and so start thinking things you might want to ask somebody who has had this odd experience that I've had of being a teacher now for more than 55 years. I started in 55 years. I started in 59. Actually, I started teaching economics while I was going to law school in 1955, and I still occasionally see some of my first students who seem awfully old to me now. And but who also, for almost 20 years now, has been a judge, and who continues to do both things. I was saying yesterday that now I'm a senior judge, which means that I sit as much as I want as a judge, and I sit 2/3 time. And as a senior teacher, I teach as much as I want, so I teach 2/3 time. And that leaves me time to come to see you and do some writings. And somebody said that means your mathematics isn't very good, because it adds up to more time than there can be. So you have a chance to grill me, and that's what that's about. Okay. Now, from the time that I wrote my first article, people started thinking of civil responsibility, of torts, as not simply or even primarily a relationship between somebody who was injured and somebody who injured that person, but rather as something that had to do with the structure of the society, as a way of thinking about things which were more public than private. And in fact, after my first article, two professors at Chicago wrote a book which talked about public concerns in a private law problem, because traditionally torts had been viewed as just, I injure you, you have a right of remedy. And this approach to torts law as a way of organizing society became totally dominant. A man named Itzhak Englard, a professor in Israel and judge of the highest court in Israel, termed us, he's a good friend, but he didn't agree with our view, and he termed us the system builders, people who view law as a way of structuring the society, as a way of structuring the society, and the torts was one of these ways. Now, viewed that way, torts not only decided how many accidents we want to have. I wrote an article provocatively titled, "The Decision for Accidents." Sounds terrible to decide to have accidents. Yet I was saying that in fact, when we say some safety measures are not required or not worth having, we are deciding to have a certain number of accidents. We are deciding, for instance, that maybe at Heathrow you should have anti-fog devices because there's a lot of fog. But in Arizona, you don't have them. It costs too much to put them in, even though there will be a time when there is fog, and there will be an accident because those fog devices aren't there. So that we are deciding all the time the terrible decision of how much safety as against how many accidents are worthwhile. And also, who bears the cost of safety and who bears the cost of the accidents. And that tort law is crucial to that decision, to that horrible decision. Now, it's not a decision that is really mathematical. That's a mistake that some people make. Costs in this sense are not easily transferable into easy money terms or things, because there are moral costs of all sorts. And yet the decision is made. And from there on, people started looking at this area of law as a way that did it. But then I wrote with a student named Doug Melamed an article which said something a bit more. It said, there are three ways of deciding what is mine and what is yours. A society decides in the first instance who has something, who has property, body. If I have two kidneys and you need one, is it mine or is it yours? Society decides first whose it is, and then it decides how someone else, how an exchange of these entitlements can take place. How something that is to begin with mine can become yours, how something that is yours can become mine. And I say in this article that there are basically three ways in which a society decides that. One is by rules of contract. It says you can only take that which is mine if I agree to it. You pay me a set price, and I say okay, and I will let you have it. Another is through criminal law and regulation. It says we, the collectivity, decide when something is mine and when something is yours, and what circumstances are that you can take it. We regulate. We say, you may take this if you need it. You may take my flowing hair if you need it. Or better, I may take your flowing hair if I need it, or not. And what circumstances? Because notice, we are not talking so much about things, but circumstances. When can you take my watch? When can I only sell it to you? When does a society say, she needs my watch, she can have it, period? These are the decisions that law makes. But between these areas where the society decides whose it is and when it can change, there is another area, which is the area of torts and of what I call the liability. When what the society does is set the price at which you may take that which is mine. Instead of saying, it is mine, but I can sell it to you, which is the domain of contract, or say, it is mine in these circumstances, but my house, but you have a right to create a stinkworks, a factory that smells, that in effect makes me lose my house, period. Which is criminal law and regulation. There is another area which says, it's yours, Guido, but this other person can take it if they pay damages And damages are set collectively, so that rather than saying, I can negotiate, you can drive your car, and if you injure my watch, you don't have to, I don't say you've stolen my watch, you have to pay what the society says my watch is worth. And that is the liability rule, and is the domain, along with other areas of law, of tort law, of civil responsibility, is what I say. And that you have these three overarching ways of structuring a society, the most libertarian way, the most free market way, if you want. A society decides whose it is, always must decide whose it is. But once it decides that, it can only change by agreement of the parties, the most libertarian. On the other hand, you have the most collective way in which the society decides whose it is and how it can change in every aspect. When you can take my shoes, when the shoes are mine, when my heart is mine, when my private parts are mine, when my hair, etc., etc. And that is the most collectivist way of organizing the society. And then there is the ideologically mixed way, and I wrote an article towards the law of the ideologically mixed society, which says that there are ways, times, in which the society decides whose it is and decides the cost at which it may be shifted. And then individuals are free to act in ways that take these, but they can't say, no, you cannot have it. They can't say, you may not drive because driving will occasionally injure me. Of course, if you drive, you'll injure people. It happens. If you run a bus, you injure people. That's a decision for accidents. But you can do it, but you have to pay the collectively determined price. Not the price that I set, not the regulatory thing, you may drive but between 8 and 9 only, and you may do this and that, and if you injure somebody, that's fine, you don't pay. Now, the interesting thing is that there has never been a society that hasn't had some of each. Even in the most collectivist society, there is a domain of contract. Some exchanges that are allowed. And even in the most libertarian society, there has been a domain of regulation, criminal law. And in all of them, there has also been a domain of torts, of civil responsibility, of this middle ground. The reason for that is fairly simple, that you cannot simply do everything one way. In a world that didn't exist even in the imagination of Ronald Coase, I could not negotiate with everybody that I might injure when I drive for the right to injure them, which is what contract would require for that. It's impossible. On the other hand, even the most collectivist theoretician in the real world knows that you cannot regulate everything. You can't do it. You cannot say everything that happens. So you have to decide that in some other way. It's interesting, in this article that I'm writing now on this, I cite as the people who imagined the perfect world and who said, in the perfect world, you can do everything one way, but then knew perfectly well that the world was not, as the imaginator of the perfect world of contract, Ronald Coase, and the imaginator of the perfect world of regulation, Trotsky, who actually said, if we knew everything, we could reach perfection through regulation. I like the idea of Trotsky and Coase being the perfect exponents of their point of view. Torts is a way of doing these things when you cannot do it in one of the other ways. But, and here is the interesting thing, there are societies that use more of one or of the other. And this fact tells you a lot about the ideology of that society. There are times when you could do things by regulation or by torts or by contracts, and the society chooses to do it by contract. Or a society chooses to do it by criminal law and regulation. But also, there are times when the society chooses to regulate by tort, by the liability rule, by saying we set the assessment, the price, and then you decide when you could do it in other ways. The most dramatic example of that is products liability. I buy a product, it's perfectly feasible to say that the risk, whether it is mine or yours, of a product that endangers people is something that is decided by contract between you and me. There are disadvantages, problems, reasons we may not want to do that, but it's certainly feasible to have a contract which says, I take the risk or you take the risk of something going wrong. Conversely, we could perfectly well say, we say when your product is wrongly harmful and we hang you, or whip you, use your corkscrew, thumb screw or whatever to do it. They just do it by regulation. But we may choose instead to do that by this intermediate way towards of saying, no, you can put out a product and it may injure somebody, and if it injures somebody, we don't hang you or put you in jail, but you have to pay compensation. So that we may choose at times when we don't need to, one or the other. And in this article, towards the law of the ideologically mixed society, I describe torts as being, in a way, the preferred method, often, of a social democracy, of something that is neither fully collectivistic nor fully libertarian. And that you can tell how much a society is that way by the times that they choose to use a liability rule rather than either a contracts rule or regulation, when either one would be possible. Okay, this is all by way of background. And this is why this article, which gets called The Cathedral, because the title is One View of the Cathedral towards property rules, liability rules, and inalienability. One view of a cathedral, the cathedral being the cathedral of law, and it was a reference to the great Monet paintings of a cathedral at Reims, in which he did hundreds of them as an impressionist, and I said you can only get a view of a cathedral by seeing a lot of them. So this is what that article is. Now, recently, there have been a group of people, of writers, whom I call Kohlberg-Zursky, which is a non-existent name, because they have been a series of different people. Jules Coleman, who was at Yale, a man named Sikorsky, who was at Fordham, a man named Goldberg, who was at Harvard, who have been writing that this is all wrong, and that towards civil responsibility is something else. It is about compensating somebody who has been injured by the person who has injured him. And saying that what is important, and there are two different views. Coleman focuses on the right to compensation. I have been injured by somebody's wrong, and so I have a corrective justice, Aristotelian right to be compensated coming from the person who injured me, which is an understandable point of view. Goldberg and Siporsky have a rather more nasty view of it, which is my right to get vengeance, call it quite that way, against the person who injured me. You injured me, I have a right. I have a right to hurt you because you've injured me. And they say that the system builders ignore this private function of law and of torts specifically, because torts is there, they say, to do this, to reflect these desires of people. Now there are people like Dick Posner who say this is all nonsense. This view just doesn't make any sense because it doesn't tell you, and he's right in this respect, when I have a right to get vengeance from you. It doesn't explain when it is mine or yours, when I have a right to do it or not, and you can only do that through system building. And to that extent, Posner is right, but I think Posner too quickly gets rid of this private view of law. And while I am a system builder, in terms of what I do, I think these people do have some truth to it. That is, once we decide that we're going to give me a right to recover against you, in order to decide how many accidents we want and how much safety we want about it, and when you can take something from me, something else happens in law, and that is this public structure makes people have expectations. So that because we have structured it in that way, you come to think that you have been injured by me and have a right to recover from me. Coleman. Or you have been injured by me and you have a right to injure me back. I don't like that, but it may well be that people come to have that. So that expectations with moral connotations come to attach to this public structure, and this is the private thing that these people have been focusing on, and I think not incorrectly in saying that these, if they said only, these are there too. Where they make a mistake, I think, and it's a fundamental mistake, is to say that this is the only thing that torts is about. They view it as being only this private relationship, which is there, which may be derivative, or may not, it may be originally, but which is one part, this private relationship. And they go so far as to say that if you got rid of this private relationship, there would not be the field of torts. So that if you structured something in the way it has been structured in New Zealand, in which everybody who is injured recovers for their injury from the state, and everybody who takes risks must pay a tax related to their risk to the state to create the fund from which everybody who is injured recovers. And by the way, those who are injured, to the extent that they created risks, their activities also pay into the state, which is perfectly fine from a system building point of view, because it charges people according to the risk of taking stuff from someone else, and so says how much you could pay to do me harm and so on. But it completely separates victim and injurer. They say torts is gone. And I say, no, the private side of it is gone, but this terribly important social democratic role of deciding when something is mine and when something is theirs, which is essential to torts in a total legal structure, remains just as much. Now, the odd thing about these Holberg-Zurskis, as I call them, is that they view torts as being entirely a matter of private law and not of system building. But when they talk about criminal law or contracts, they view it entirely as a matter of system building and not of private. And that's a mistake too. If it were so, if there were no private matters that mattered in contracts, then the so-called Holmesian heresy would not be a heresy. What did Holmes say? Holmes said, Oliver Wendell Holmes wrote that anybody has a right to break a contract when performance is more expensive than breach. That's system building. That's saying we only want what is mine to shift to yours when it's cheaper to do it that way. But that has been considered a heresy because it ignores the private side of contract, that I have come to have expectations that you will live up to your promises. That's the same kind of individual relationship thing. The Kohlberg-Zurskis act as if contract is entirely a matter of shifting by agreement and that there is no private side. Similarly, they act as if criminal law is entirely a matter of public structuring of a society and that there isn't the right of the victim to say, gee, I've been injured by you in a criminal one. And it's funny, it's a kind of, they're almost Posnerian at that point, which is remarkable. So I say in this article I'm writing now that each of these areas of law that determine what kind of a society we have, libertarian, collectivist, mixed to various degrees, have a system-building public side and also a private side that is there. And which is more important, which you want to do more with, depends on how expensive, and I'm not talking here in strictly money costs, it is to have one or the other or both. If having all these individual lawsuits and injurer and victim next to each other is too expensive for what it is worth, we may well decide to make torts an entirely system building, as they have in New Zealand, and lose that individual relationship that Kohlberg-Zurskis think is so important. Similarly, we can do one thing, the same sort of thing, with contracts or with criminal law. That's a decision to make, depending on how important we think the private is in relation to the public. Public can't be avoided. It's always there. It's always there in all of these, because it's the structure of society. But how important these private relationships are is a matter of comparative advantage, of how easy it is. Now, here, be careful, because one of the things that determines this is how are there available other substitute ways for the society to reaffirm the values that, say, the private relationship would give. Are there other ways of saying promises are important? And we will let people do what the Hohenzollern heresy would do, but find other ways of saying, you know, promises are important. Similarly, in torts, are there other ways of saying, you have injured me, and while in terms of compensation and the whole structure, we do it in a New Zealand way, we also find a way of saying, you have a right to feel compensated. One way would be to charge the injurer, in some circumstances, a non-insurable, because there's something very odd about saying, I have a right to go after you, when the person I really go after is your insurance company. I mean, most of tort law does not involve at all any one-on-one, because there is insurance, but to say, allow people to get a smaller amount, one which is not so huge that it keeps people from driving because they're afraid they'll have to pay all of it, which is why we have insurance, but an amount which you can't insure against, which goes to the victim so that the victim can say, yes, I got something from this one, while having the whole structure instead be a New Zealand structure. And notice, the moment you start thinking that way, you start saying, well, that amount maybe, unlike tort damages, ought to depend on the wealth of the victim, of the injurer, so that it has that effect of making me say, I've gotten something from you. And it's kind of interesting that some of the more advanced legal systems, Denmark, for example, have been experimenting with non-insurable tort fines in which the size of the fine depends on the wealth of the person fined instead of not. So, which we do, how important we do this public-private, is depends on whether there are alternative ways of doing that which we decide is too expensive to do as part of the system. Okay. All this is still background to what I'm saying now in this article, although I say all this in the article because it deals with people who are revisions. What is the mistake that I think was made by many people who have written about the cathedral? And when I say by many people who have written about the cathedral, let me say that that literature is immense. Some people who do these kinds of studies, I don't say that this article that I wrote with Melamed is the most cited private law article ever. There are more citations to it than to anything else. I think that depends on what is private law and what is public law. If you view it as public, or maybe other. But in any case, it is certainly true that it is one of those articles that there is almost an obligatory citing, sort of bowing to it and then saying something else. But in much of that literature, and even when I went back and read the article, I don't think I meant it, or my student Doug Melamed meant it. There is a suggestion that the liability rule price, that which the person must pay to take what is mine, the damages, if you wish, should be set in a way that comes as close to being the market price if a market were feasible. That it should be that which, if people were able to negotiate for when you take something of mine, and did, what price they would set, the contract price. If I could go out and buy from each of you the right to injure you occasionally when I drive, what that would be. In other words, that the liability rule should mimic the market, should mirror the market. But that turns out to be wrong. And wrong both in theory and in practice. And here, one thing, it's an example of what I'll have more to say about tomorrow, about the notion that you make a theory and then you don't look to the world and see whether your theory explains the world or whether the world is different. In fact, the damages that are set in the real world don't always mimic the market. They don't do it. And if people were more empirical, more realistic, they would have realized that far earlier than now, 40 years after I wrote that article, of saying the liability rule is not simply there to mirror, to mimic the market. There are times instead when the amount that you are made to pay to take my entitlement, to take what is mine, is not the market price, doesn't approach, mimic the market price, but comes very close to criminal law or regulation. That is, there are times when we want to make it very difficult for you to take what is mine, when we want to make the cost of it be much greater, even though for some reason we either don't or can't make it criminal. There are times when what we want to do is mirror the market and say, if there was a market, that's what we would want. And then we make the price be what the contract price would be if we could figure it out. But there are other times when instead we want to make a price which says, we don't want you to do this. Now you have a right to do it. We won't jail you, we won't hang you, but boy, it's going to cost you a lot if you do this. And we see that in the world all the time. In punitive damages, that is, damages that are extra compensatory. In runaway juries, allowing juries to give damages that reflect the anger of the society at what has been done, even though it is more than reasonably compensates the people, is there are times when, in fact, the liability rule mimics criminal law, mirrors, comes closer to, though it's not, criminal law regulation. And there are times when it mirrors the market. But there are also times when it gives less than compensation. When we want people to be able to take away what belongs to somebody, and we think that's useful enough for the society, so that we say, yes, you'll have to pay something, but it's not what the person would have required in a contract situation. So we do not give full damages for emotional losses. We do not give full damages for pure economic losses. We say, if you want to negotiate that contract on that, that's fine, but if you don't negotiate, the damages you get are less. That is, just as in the real world, we charge more than sometimes what the price is. Now be careful, because there are sometimes when we charge more that we are actually doing something which is approximating a market price. This is a little parenthesis. When we give punitive damages, not to say we don't want this to happen, but to say only one person tends to bring suit, but 10 people are injured. We must when the one person brings suit, give damages which are 10 times in order to make the cost be the market cost. This is called the multiplier, and the former clerk, student of mine, Captain Sharkey, has written much about it. And both Posner and I, as judges, have written an opinion explaining why that has to be. Class action is another way of doing the same thing. That's a strictly market mimicking way of punitive damages. But there are other times when there is no multiplier, and where we give punitive damages because we want to say, if you do something of this sort, we won't jail you or hang you, but we want to discourage you from doing activities of this sort, which do that. The Exxon Valdez case is an example of that. That's the oil spill in the Arctic. There was no multiplier effect there, yet the punitive damages were very high, because what we wanted to say there was to say, if you're going to take a chance on having oil spills of this sort, we may not put you in jail, but boy, you're going to have to pay an awful lot more than what is needed just to compensate the victims. And I say, in torts, you have it both at the upper end and you have it at the lower end of giving less. The interesting thing is, if you look at this in another area, which is dominated by the liability rule, which is eminent domain, the taking of somebody's property for a public purpose. If you look at eminent domain, it may be that and it's a perfect example of a liability rule. I'm not selling the property to you, but you have a right to take it, whether as the state or as an agent of the state, the railroads or something of that sort, if you pay me a collectively determined price. If you pay me compensation. Okay? That's what eminent domain is. You have a right to take what is mine, but you have to pay a set price. Okay. If you look at eminent domain, you can set the price at that which would have been what I would have sold my property at an unforced sale. Market value. But in many places, that isn't what is paid. In Italy, for many years, and in much of Europe, the price that was paid was not the market value, but the value in use. How I was using the property. So if I had a great villa estate, which I could have sold for much more for industrial development, but I was the lord of a manor and I wanted to live there in that way and use it for farming, and the state decided it wanted that property, it didn't pay me the value of that for industrial development, it paid me the value of that as a farming villa, which would be much, much less. That is, the collectivity said, here we want the entitlement, the property, to shift from one to another, not at market value, but at less than market value, because we want to encourage this kind of shift. I know that all too well, because my great uncle, who was a great economist, owned a very large villa estate outside of Bologna, and the city was getting nearer, and the land was becoming more and more valuable as development land. But he didn't sell it for that. Now, he claimed that he didn't sell it for that because, being an economist, he had figured out that the increase in value that would come in a few years as the city got closer was higher than the rate of interest that he would lose And so that it wasn't yet the optimal moment in economics to sell. It may have been that, it may also have been that this grand old gentleman wanted to be the lord of a manor. I don't know what it was. Fact is that when at a certain point the city of Bologna decided it needed an airport near the city, and it looked out and said, where is there a lot of open land that we can get? They looked and found Guido's uncle's villa, and they took it by eminent domain, and they paid the old gentleman who said that shows you how much law doesn't understand economics. It was an economist's typical incapability to understand that law was doing what it was doing, and paid him value in use, with the result that Guido, who you need to worry about in this, is much poorer than he would have been. My great uncle had no children, so part of that would have come down to me, that if my great uncle had gotten market value for them. Okay, that's one side. But that's not the only side. There was recently in the United States a very controversial case before the Supreme Court, which is called Kelo, K-E-L-O, in which, in the town of New London in Connecticut, not far from where I live, the town had given the right of eminent domain to a private developer to take properties, privately owned homes, to upgrade and redevelop the area. The area had fallen into some slums, was poor and not very good, but there were private houses owned by individual people. And the city, not incorrectly, thought that the area, which was near the harbor, was an area which could be made into a very elegant and would be much more worthwhile for the city if this were developed in a different way than what it was. So they gave a private developer the right of eminent domain to take these properties. The individual owner sued and said, you cannot take that. And it went all the way to the Supreme Court, who said, yes, you can. And that caused a big fuss. Any number of people got very angry. They demonstrated in front of the justices, saying, we'll take your houses, and other things like that. In the middle of the argument, Justice Kennedy, who is not the brightest, the sharpest knife on that court by any means, but this time he saw something, said, wouldn't we feel much better about this if, in this case, instead of giving the market value of the individual's houses, we gave 3 or 4 times it? That is, we said, yes, you may take it, but you have to pay a higher price. We want to discourage this happening, but we don't want to forbid it. We want to give damages which are extra compensatory, because we want to say this can be done privately, but you have to pay more than a market price, so we don't mimic that price. And of course, when people see that, they say, of course. Where you have a private developer doing something of a public purpose, but which takes individual private property, maybe we don't want it to happen just at a market mimicking price. That says that this notion that the liability rule should be as close to market as is possible was a fundamental error. And it was an error based on the fact that the people who did it and who wrote about it, being by and large lawyer economists, tended to think, like many economists do, in terms of market, rather than in terms of collective decision. And so psychologically, they just assumed that this social democratic price should be the private libertarian market price. But that is wrong, even as a theoretical matter. Because if it is a social democratic price, it doesn't have to be the libertarian market price. It should be a price which reflects the values of the collectivity. The collectivity may not want to be so collectivist as to forbid the exchange altogether. It may not want to be collectivist. It doesn't want to be as libertarian as the most libertarian side. It has its own values which it puts into the liability rule, into the price at which the entitlement can change. That is, if you really think of liability rule towards eminent domain as the law of the ideologically mixed society, then it isn't a bit strange that the price that is put in the liability rule will vary from approaching the collectivist to approaching the market to anything else in between, which is what reflects the values of that social democratic, ideologically mixed society. And that happens to be the way the real world also is. So that you see these prices differ. Now, at this point, when I showed my article to a very good philosopher of law, towards scholar named Greg Keating, he said, then you shouldn't call it prices. Because prices itself suggests market. And I said to him, well, it's too late for me to change this article, but you're absolutely right. So I dropped a footnote that said, you know, in the future, it might be better not to call them prices, but that when they reflect or mirror or approach collectivity, probably we should call them penalties. When they reflect or mirror the market, probably we should call them prices. And when they reflect something which is completely different from either, but simply the values of the social democratic collectivity, then it should be called assessments. Something else. It really doesn't matter what you call them, so long as you know what you're doing, but you're doing something which isn't market and which isn't collective, which is something in between. Now, let's go back to the beginning and see if what I've been saying makes sense to you. Let's go back to the Kohlberg-Zorskis and see why their view of what this area of law is so impoverished. Because it doesn't take into account any of this. That doesn't mean that they are not reflecting some values, some things that the society also wants, and in that respect Posner is wrong. But to say, if these values were not there, we wouldn't have a field like torts, is so wrong. We would have them, you just have to have other ways of dealing with these values. And that's what I call a broader view of the cathedral. Let me end by saying that what all this involves is something that I apparently wrote in one of my opinions as a judge. And another judge just found it and sent it to me as a quotation. And I kind of liked it. It's kind of nice to hear yourself talk and find that somebody likes it. See, what we're doing here is something which looks very mathematical, you know, of putting in costs, of saying this, when is this kind of cost? But we're doing something which is a little different. And here's my quotation, that what is needed is a sense of balance which allows one to weigh that which cannot be measured. You know? A sense of balance which allows one to weigh, to give weight to things which we have to take into account, but which we cannot measure in strictly mathematical way. And that is an awful lot of what law is about, and that is what is most difficult for people like you, who are doing something in law and economics, to keep always in mind. Now, there are two ways of looking at it. They say that when the library in Chicago was built, Chicago, which is a state of mind, not a geographical place, somebody said to put on the library a sign that said, if you cannot quantify, your knowledge is meager and vague. And someone else said, put underneath it, I'll let you put that on, if you put underneath it another thing which says, and even if you can quantify, your knowledge is meager and vague. To which the first person said, fine, but put underneath it, and even if your knowledge is meager and vague, quantify anyway. That's the point of view of Chicago. My point of view is what is needed is a sense of balance which allows one to weigh that which is not measured. And that's what we're trying to do in this area of law and in law in general. Thank you. I've talked at you for an hour, which was my plan, and now I'm here to answer any questions that you may have. Now, one thing to keep in mind, I am very hard of hearing. That's a polite way of saying I'm deaf. And that means that you have to speak up, and that I will probably come up right next to you when you speak, so that I can hear what you say and I may ask you to repeat it. When I teach a class, I teach a class of 70, 80 people, and I do it by asking questions. I use the Socratic method, the traditional method we have. And I don't stand at the front of the class and ask questions. I go up, I do a question, and then ask you a question. My students all think, isn't he nice? So polite coming here. And it's only after 2 weeks, when I've got them, that I tell them the reason I do this is that otherwise I couldn't hear them. So I may do that here. So ask questions, and if you don't ask questions, I may start calling on you. So what would you like to know from somebody like me?
Professor, I'm wondering, personally, do you...
I'm sorry, loud and clear.
I'm wondering, personally, do you agree that the pure economic laws
That's
should
that?
be... Pure economic laws should be...
I'm not hearing.
Pure economic
Oh, the
laws.
pure economic.
Yeah, do you agree that the pure economics laws should be compensated?
With where there's only purely economic loss, that it ought to be compensated or not.
Yeah.
Yeah, well, traditionally in tort law, purely economic loss is not compensated. And why that is has always been puzzling to me. Because there's really, you see, I can understand why we may not compensate for purely emotional loss. Because from a purely economic point of view, if it is the case that there's no doubt, let's say, that if you are driving down the street and you see a horrible accident caused by his negligence, that you feel sick to your stomach. You see blood and gore all over the place, his private parts sort of lying there, mangled and so on. And and you feel sick. Why isn't that a cost of his negligence? And yet we don't give you those damages. Except in some odd circumstances, as when you see a child of yours being killed or something. The reason I think for that is because this is a situation in which if we give you damages, you feel them more. They become greater. If you have a right not to be made to feel sick, your damages increase, not because you're faking, but because you focus on it and you think about it and it becomes greater. So if what we're trying to do is lessen the damages that his negligence caused, and don't worry about your becoming callous in that situation, because after all, there are other people who worry about that. Why should you get so concerned over the fact that you've seen blood and gore while you're driving by? We will say we don't give you those damages for a purely economic reason of reducing those. But in situations where we don't want you to feel callous, we will give you, like a child seeing, mother seeing a child, we will give you that. So I understand how that has an economic basis for it, apart from any of this collectivity thing. I have never quite understood what the economic basis for not giving straight economic losses, pure economic losses are. That is, I can understand the not giving of pure economic losses because that would make people so liable potentially for such great things that they would not do things which the collectivity wants. So that in terms of what I've been talking about today, of a collectivist view, social democratic view of why we don't want to give pure economic losses in many circumstances, we might do it. I don't see the pure economic one. Now, some people say that those are situations where there are, that pure economic losses are of two sorts. One, where they are relatively narrow, which from this broadly collectivist view, we would be perfectly happy to give them. But in those situations, a negotiated contract is feasible and preferable, so we don't give them to you because we want to encourage you, give you an incentive to enter into a contract. And that there are other situations instead where such a contract is not easy, difficult to do, and that in those situations instead the damages that might be recovered are so enormous that people wouldn't engage in activities which we collectively want them to, so we set damages at a lower level. And this view of it would say the rule then has to be applied by courts in a manipulative way so that if there are relatively narrow levels of economic damages where contractual relationship would not be possible or easy, that there we would give them. We would award the damages. And I haven't had that many cases as a judge of that, but my instinct is that that is exactly what we do. So that the rule is less a hard and fast rule than a rule that allows courts by intuition to see those situations where the collectivity has said, no, this is too great, and those situations which say they should have done it by contract, where they don't give them, and those situations of pure economic damages where they say, okay, we will give them. And I think it would be very interesting to do a study, a real empirical study of the cases in various jurisdictions in the United States, for instance, to see if this instinct of mine is right? It's a very good question. It's caused me to think about something that I hadn't quite thought of in that way, but I wouldn't be surprised if a study came out to say that's what's going on.
I wanted to ask you whether you agree with the fact that your thesis is one of the demonstration of all this view of the liability rule would be that on these matters, civil law and common law are not that different, in the sense that here, for example, or in France, we have a broad article in the civil code saying basically whoever caused an injury has to pay it, but through the word cause, therefore through the causation, judge actually just allocate costs and according to yes the actual reasoning that you made before. So in this sense, are the judges that actually make the duty of care and decide who has to bear the cost of an accident. And one other thing is that
He always asks two questions.
yeah.
He did last night, too.
And then I just
Why don't I answer this one and then I'll...
Okay.
The question is the civil law and the common law really that different in doing what I've been talking about? And I think the answer is there's almost no difference. What we do, who does what, may differ somewhat. And here, for example, it's the reason that economic analysis of law, or law in economics, was accepted in civil law countries much more slowly, much more reluctantly at first than in common law countries, because those who wrote about it at the very beginning, Coase and me, and then those who wrote about what we had written from the very beginning, were writing in a common law context, and so were addressing what we were saying to courts, because their courts could do these things. And so people in some civil law countries said, that has nothing to do with us because our courts can't do that. To which some of us finally said, okay, it doesn't have to be courts, it may be legislatures, it may be administrative agencies who can do this, but the same kind of issues need to be decided by whoever are the appropriate decision makers in your system. And it's at that point that economic analysis started becoming important in these countries as well. What has happened, though, since is that both in the common law there has been much more written law, much more statutorification, as I call it, even an ugly name, and that in the civil law there are clauses of the codes that are broad enough so that they not only allow but require the civil law courts to do the kind of thing that you are saying. So you are pointing to causation as a word in the civil law that allows courts to do that. We have seen the identical thing in common law where statutes have been passed going from contributory negligence, which was a silly old rule in which if the victim was negligent at all, the whole loss lay on the victim, rather, even if the injurer was quite negligent. And statutes now, almost all states, not all states, Maryland is still contributory negligence, but most states in the United States have gone to comparative negligence, and many of them have done by statute, in which comparative negligence was put in. But it didn't take long for the courts with those laws to say we are comparing not degree of fault only, but also degree of causation. and using causation there to say we are comparing degree of responsibility and duty, and do, in that context, exactly what you are saying the French courts are doing. And the answer to that is the language and the structure may be somewhat different, but to the extent the underlying problem is the same, you are going to get the decision makers tending to make the same decision. And when I say the same decision, that itself will reflect the degree to which these societies are cognate, are parents, so that you might expect a very different decision to be made perhaps in India, if the values of India are very different from those of Italy, or not. But to the extent the societies look at these problems and at the collective level have a similar view of what ought to be done, then you will find the decision makers of these societies coming up with very similar solutions using the techniques that they can do through the language of law. Causation is a wonderful word for that, to do it. So in fact, French law and American law and many of these things are very close. Because after all, France and America are cognate societies. And all these Western countries are perhaps too similar. It could be useful for us to see some view that is a little different. We can't. Those of us who are from here have a little difficulty getting out of being Eurocentric, but there it is. That's what we are. It's our problem. What's your second question?
It's just that it's kind of I wanted to share that, for example, we in Italy, the case law does not recognize punitive damages, but that is kind of like, if you go through that case law, is a huge demonstration of your view, in the sense that when they want to give punitive damages, they just say that that's the market price of something, and there's huge contradiction because it's quite self-evident, and most of the time it is not. Yeah. So they kind of use a market approach, trying to justify the fact that they want to give like punitive damages or
yeah. And that is again an interesting thing, because that is true here. Now there has been a move more favorable to extra compensatory damages, which is what I like to call them, rather than punitive, because sometimes they're meant to be punitive, that is to mimic criminal and regulatory. Sometimes they are just multiplier, so that we, and that's something that our Supreme Court has not understood, but they're finally being made to understand it. But in Europe, there has been some slight tendency to move in the direction of allowing extra compensatory damages. What there has been the development of class actions, which, as far as the multiplier effect, is a way of dealing with that. Only one person sues, but that person sues representing the other 9, which takes care of that. So that has been something that has developed. But as you say, even where you say we do not have them, there are cases where it seems appropriate to give damages which are greater than what would be normal compensation, and then you call it something else. You say it is compensation, but it is bigger. And as my teacher, Fleming James, said, you can call it Thucydides, or you can call it mustard plaster, but it's all proximate cause, just the same. You can call it by different things, but if you do the same thing. The fascinating thing is that in the United States, in some jurisdictions, some states, under pressure from injurer activities, punitive damages have been either eliminated or greatly limited in certain areas. So, state passes a law that says we will not give punitive damages in medical malpractice cases. The same student who is a professor, Kathy Sharkey, a professor at NYU, has done a study which has shown that in those states where that has happened, compensatory damages for pain and suffering and other things have been given which are much larger than in states which allow punitive damages. In other words, the juries or the decision maker does there exactly what you say. Oh, you won't let us give these? We think these should be given. We'll call them by a different name and give them just the same. Which is another way of showing how similar the civil law and the common law are. If the problem is the same, you may say, gee, we don't really want it for some reason because we don't want to call it that way. But if that is something to which the society wants to respond, they'll find another way of doing it.
Hello.
Hello.
Thank you very much for the lecture. It was an honor attending one of your lectures, first of all. I want to clarify that I come from an international and European studies background. So my question has to do more in general things. For example, I found quite fascinating one of your opinions that establishing and accepting same-sex marriages can be done in America and USA through the First Amendment on religion and how you correlated these two notions. But I was trying to understand how that could work more in a European background.
Yeah, how, see, the question of the acceptance of same-sex marriage in the United States has been a very, very interesting thing. The first person, the first court to do anything of that sort was the Supreme Court of Massachusetts, in which the Chief Justice was a woman named Margaret Marshall, who has now retired as that. She actually is the head of the Board of Trustees of Yale University. She's become that since. She has a very interesting background. She was born in South Africa, and she fled South Africa because of apartheid. She is white, but she was part of a family that was opposed to apartheid and segregation, and so she had to flee and was a refugee to the United States, did very well, came to Yale Law School as a student, was my student, and then moved to Massachusetts, became the lawyer for Harvard University, then was put on the Supreme Court of Massachusetts, and then became Chief Justice of Massachusetts. She used the Equal Protection of Laws clause that the Massachusetts Constitution had, not the federal one, because she was wise enough to know that if she had tried to do it at the federal level, the country was not ready for that, to say this is something that must apply across the whole nation, but might be willing to say an individual state can make this decision and experiment with it. And she used that language. Now, what can a society that doesn't have similar language do in the Constitution? And what can a society that doesn't have the kind of federalist structure that allowed her to say, this will be the law of Massachusetts, and I don't care what you do in Texas. It's much harder. That society is going to be much more reluctant to do anything until and unless enough other societies go that way so that it becomes enough of a fundamental right so that you can say, under the equivalent of due process, under the equivalent of fundamental liberty rights that a person has. But that is a step that is always more difficult than something which says you can't discriminate. It's harder to say, it's a more aggressive position for a court to say, this is a fundamental right. You have a fundamental right to same-sex relationships and marriage, than to say, we will not treat your view of marriage in a discriminatory way from somebody else's. It's a further step, so it's slower in coming in that. That doesn't mean that it won't come. And the thing I have in mind is something which is very local in the United States, but the judge I clerked for on the Supreme Court, Justice Black, was a person who was very concerned with the language of the Constitution. And he was the great leader, even though he was from Alabama, and had grown up in a society that was totally racist. He became the great leader for integration and Brown versus Board of Education and the destruction of segregation, apartheid in the United States. He was the great leader of it. And he based this, because he was language oriented, on the Equal Protection of Laws Clause. Soon after, there was a case which involved segregation in the District of Columbia, the Federal District of Columbia. The difficulty for him of that was that the Equal Protection of Laws Clause of the American Constitution is part of the 14th Amendment, and it applies to the states. States may not deny individuals of equal protection. There is no equivalent with respect to the federal government. Both the 14th Amendment and the 5th Amendment have a due process clause. No one shall be deprived of life, liberty, or property without due process of law. But the 14th Amendment goes on and says, and no state shall deprive people of the equal protection of laws. There's no equivalent part in the 5th Amendment. And the District of Columbia is not a state. It is a federal entity. So that what he had used to order desegregation in the states, he had no linguistic hook to do in the District of Columbia. And, of course, people sued to desegregate the schools in the District of Columbia. The case is called Bowling v. Sharp. And Black went along with a decision that said due process requires this. And I asked him how he could do that when there was no linguistic hook. And he told me something very interesting in terms of judges. He said, first, the District of Columbia did not have a government of its own. It didn't have an elected legislature that made laws. Here was this city, which was predominantly black, but which was governed not by the citizens, but by the Congress of the United States, the national parliament. No, not by the Congress, by the House of Representatives, one of the two houses. As a practical matter, they named all the laws. No, not the whole House. As a practical matter, the committee of the House of Representatives for the District of Columbia. That legislative committee decided the laws of the District of Columbia. And that committee was dominated by white, rural Southerners who made the laws for this multicultural and predominantly black city, and who wanted nothing more than to be able to say to the Supreme Court, you have ordered desegregation everywhere, but you don't order it in your own backyard. That's what they wanted to do. And Black, at that point, said, I couldn't do it. And so even though he had no, see, the difference is there were some justices for whom due process was a growing concept. And they could say due process has come to incorporate equal protection. Black was linguistically traditionalist, and he didn't want due process to be an expansive concept for other reasons. And so he shouldn't have been able to go along. But he said, but he did. And he ordered desegregation of the District of Columbia. And I said to him, how could you do it? And he told me something which was very interesting in terms of the role of judges. He said, a judge who doesn't pick a legal philosophy among plausible legal philosophies, but allows her or him to come out right, as he or she thinks, most of the time, is going to be a very unhappy judge. You're going to pick a philosophy that allows you to come out right as you think it most of the time. It has to be a plausible one that has historical, philosophical basis. And he said, Justice Frankfurter has picked his philosophy, which is very different from mine, and allows him to come out the way he wants most of the time, and I picked mine because it allows me to. And he was thinking of another Judge Jackson, whom he thought is a very unhappy fellow because he's picked the wrong philosophy for what he wants to do. Then he said, a judge who having picked a philosophy, doesn't from time to time have to come out in ways which he or she doesn't like, because the philosophy requires it in ways different from what he or she would vote for politically, is not a judge. Because once you've picked a philosophy and you've taken an oath for a judge, you do what your philosophy wants. So there was one case in which Justice Black said, this is an uncommonly silly law, but I can't find it unconstitutional. Okay. But then he said, but a judge who, having picked a philosophy, thinks that any philosophy, no matter how broad and wise it is, will cover every single case, no matter how important, no matter how crucial that case is. That man's a fool. That man's a fool. And he said, there will be circumstances, they have to be rare. Otherwise, a judge can do anything that he or she wants. When a judge will have to violate his or her philosophy to come out right. And this case was one of them. But it has to be very rare. And he said, when you do that as a judge, you are standing naked. Because you are doing something that violates your philosophy, and you are asking people to criticize you for not acting as a judge. If you do it when it isn't necessary, when it isn't right, because it isn't that extreme case, you will get plenty of criticism, and you should. And people will say, what a jerk, what a fool, what a non-judge, what a this and that. And that's the only way of controlling judges, that they can do it. If you happen to do it in a case which is really the extreme case, when that's the only way, probably no one will criticize you. No one has ever criticized Justice Black for Bowling v. Sharp, because he did it in an extreme situation where it was the only way. What he said to me, this old Southern Baptist, said, I viewed that case and I said to myself, lapsing into German, hier stand ich kann nicht anders, Gott hilfe mir. I don't know how many of you know what that is. That is what Luther said when he posted his statement on the wall in breaking with the Catholic Church. Here I stand, I can do no other, God help me. And like was saying, there are times when a judge will do that. Now, back to your question. At what point will a judge do that when the law does not permit it yet? At what time will the law of neighboring states change sufficiently so that some clause that isn't very helpful, not as helpful as equal protection, but which is there, can be read in that state to allow it? Hard to say. Hard to say. One can predict somehow that it will happen. And I'll tell you another story. I have a law clerk, a former law clerk, who is now a professor at NYU. His name is Kenji Yoshino, and who is one of he's a great scholar, and he's one of the leading writers for gay rights. He is himself gay. He is married and has 2 children. I married him. I knew he had moved to New York because he wanted to meet someone. He had been with us, but New Haven is a small city and he hadn't found anybody. And after he had moved there and to NYU, he met somebody, and they were clearly very much in love. And Connecticut had just passed, the legislature had just voted to allow same-sex marriage. So I said to him, I don't want to interfere in your private life, which is always a statement that comes before an interference. But should you want to get married, in Connecticut it is allowed, and I think I know a farm which is very beautiful, which is where I live. We've had it for 60 years, which is why we were able to get it. It's an old New England farm, which would be a nice place to have a wedding, and I think I may even know a judge. So 2 weeks later, he said, we want to be married on the farm, and it was the first same-sex marriage in the area. And they came and they set it up all beautifully, and I did the marriage. But then something interesting happened, because when I do a marriage, and now I used to do many of them for my students, but it turned out that so many wanted me to do them that I had no weekends. So now I only do marriages for my former clerks, and for members of the law school faculty, from the Yale faculty. When I do marriages, I always at the end say, not wearing my robe, but I don't wear a wig, but because I'm not an English judge. And now, by the authority vested in me by the state and the nation, I declare you to be married. But in this case, saying that would have been something odd, because Connecticut allowed same-sex marriages, but the nation did not. Indeed, the nation at a national level prohibited it. This was what was held unconstitutional last year. Nonetheless, when I did that marriage, I said, and now by the authority vested in me by the state and the nation, I declare you to be married. And Kenji, who is a big one in symbols, understood immediately that what I was saying was, I have the authority by the state, I am a national judge, and I am saying that this federal law prohibiting it is unconstitutional. So that without actually, That's what I was saying symbolically, which was predicting that which would come. Other questions?
Could you please tell us a little more about the public compensation? The public compensation fund instrument, not
The
as
public compensation
fund.
fund. Oh, the New Zealand.
Not as a substitute of the tort law, but as an integration of the tort law. For instance, as it is used in France.
Or as in 9/11 when you have a public compensation which does that. Yeah. Again, if you are concerned with torts and compensation as a public thing, not just a private law thing, you have situations in which you do not want the injurer to have to pay for the harm done. Just as you may have some situations where you want the injurer to pay directly because you want that relationship to be there, even though the compensation is done in a New Zealand way, so you may have situations where you do not want the injurer to pay the whole cost or even most of it because it is too great a burden to put on those activities, to have certain types of things. It would destroy them, and that the social democratic state, the collectivity, decides is not desirable. Nonetheless, it wants compensation to be given. It wants the victims to recover. So what it does is create a fund which is fed in part by contributions from insurers, but in part also from general taxes, as a way of giving to the victims what makes them whole, and yet charging an assessment of the injurers which is not the full cost. This is a perfect other example of the liability rule, if you want, responding to a collective desire rather than to mimic just the market or to mimic criminal law regulation. It is a decision that we want to do it that way. It was not one I had thought of, so I'm particularly grateful to you. It again is not something that is in the article, but which serves as a very good example of this, and I will use it at other times in that. Now, why might one do that? Well, it might be that the destruction of those activities, really exposed by charging them with that, is too, it has too many, as the economists with their usual infelicity of language say, externally negative effects, because too many people would lose their jobs because companies would go broke and so on, and we don't want that to happen. So that may be why we have this form of bailout. There are any number of reasons why that might be, but you can see why that is. The interesting thing is that this has not just happened now in a thing like 9/11, where the compensation fund is set up in the first place, or in situations where individuals may be held liable. But historically, there have been some very, very gross, very enormous damage situations where the courts, in situations where normally the law of torts would say the injurer is liable, have found ways of saying the injurer is not liable, because that was the way of creating the greatest incentive for the society as a whole to create a compensation fund. That is, by saying that the usual private way on which the injurers pay was not available, for whatever reason, was not proximate cause, or whatever use of language they used. Therefore, these poor victims would be out with nothing. It led the collectivity to do what the courts believed was a more attractive way of having it be compensation to victims, not put on the injured. The Texas City disaster, a case in which in the 1940s a ship, a private company, blew up and destroyed most of the city. Not just pure economic damages, but damages of a size that were the equivalent of economic damages, but lots of physical damage as well, and where obviously the victims should be paid, but destroying this whole shipping line was not something that the courts were willing to do. They found a way that made no sense in tort doctrine of saying no liability, which led to a public compensation.
I think in Europe we go further.
I've got to come back and hear you.
I think that in Italy and France, especially in France, we go
In
further.
Italy?
And France, we go further. In the sense that we use this instrument also when there is no injurer. Either because there is no negligence or because the injurer disappeared, but still we think that the victim needs a compensation.
Yes. Now, these can be slightly different things. That is, the situation in which the injurer has disappeared is a recurring theme, and it's one that I teach a great deal about, because then what you have in most countries is a public compensation fund, but one which is structured like this. What I use is a statute in New Hampshire about dogs and sheep. When dogs worry, that's the technical word, sheep, that is, attack sheep. In New Hampshire, the dog and the dog owner are absolutely liable. No requirement of fault. That isn't terribly important, but it happens to be a strict liability statute. If you know whose dog it is, the dog owner is liable. But if, as often is the case, you don't know whose dog it was, then the payment to the sheep owner is made from a fund established out of dog licenses. That is, if you have a dog, you have to get a license for the dog, and part of the cost of those licenses is to compensate sheep owners for unknown dogs. Now, that creates an incentive on dog owners to try to identify the right dog owner, because otherwise their license fees goes up. But it also does something else. It tends to create dog licenses that charge more if you want to have a German Shepherd that is a great big dog that tends to worry sheep than a Chihuahua, a little tiny dog that even a sheep could kick. And more, incidentally, to male dogs than to female dogs, because it is also the case that, this is very sad for you men, but it is pretty clear that males are more aggressive than women, and that this is something hormonal. We don't behave as well. And there are times when it should cost us more. We may say that we don't want to do that because of gender equality, or we may not. Fact is that most automobile accidents which involve deaths in the United States involve males, drivers, between the ages of 18 and 26 who are unmarried. We are much riskier. So are male dogs. So you will have this fund set up in a way that charges more to large male dogs owners than to little female chihuahuas. But to make sure that this fund is enough, the New Hampshire law says, and if the licenses are not enough to pay for it, then this must come out of general taxes. So that the city has an interest in making sure that the licenses create a fund that is enough to do this. So this is the public compensation fund that is designed to put the cost of the activities that do it and yet cover. Now, is this because we want compensation? Yes. But it is also because we think this is a cost of dog owning and that this is the best way of doing it. So one of the things you want to look to in the compensation fund that is set up is to what extent is it entirely a matter of wanting to compensate the victim and not worrying too much about the people who are the riskier activities bear that cost, which some of these funds do, and what times is it instead a way of saying it is difficult to identify the individuals, but we want on a causally related, statistically likely that you are doing it, market share if you want, way of doing it, without identifying the individual, way of doing that. When in the United States we require drivers to pay a certain amount into a fund for injuries caused by uninsured motorists, which includes motorists who are hit and run and fled, we're doing exactly the same thing as the New Hampshire sheep and dog statute. So that's one of the things that does. Good.
This is a completely different question. Yesterday and also today, you expressed yourself against death penalty. So I wanted to know a little bit more about the role as a judge that has this, that finds a law that is immoral, but that actually exists.
This is a long and complicated business. I'm against the death penalty. Can you hear me even though I'm sitting? I'm against the death penalty on any number of levels. That is, I'm against it on moral grounds, religious grounds. But I'm also against it on grounds that from a utilitarian point of view, it doesn't work. Ever since Beccaria, the evidence has been quite clear, for reasons that aren't altogether clear, that having or not having the death penalty does not make any difference in the number of murders that there are. And the evidence is very powerful because it isn't only evidence of a jurisdiction that has it and then has dropped it or didn't have it and puts it in, there isn't any change. The most dramatic evidence is if you take two jurisdictions which in various ways are extremely similar to each other, and one has it and the other one does not, that their homicide rates are just about the same because they are so similar. So in the United States, Michigan has never had it. Illinois has had it. They're adjacent states. They're both states with one huge city, Detroit in Michigan, Chicago in Illinois, and very rural downstate areas. So they're very similar, no difference. Or for many years, Rhode Island, which didn't have it, and Connecticut that did, very similar and no difference. So New Hampshire and Vermont, New Hampshire did in Vermont. So the evidence is quite clear that and that's important because utilitarianism takes no prisoners in the sense that if the death penalty actually diminished the number of murders, someone could say, yes, every once in a while somebody is unjustly executed, either because their crime was not as serious as somebody else's or because they were innocent. But you know, if we save 10,000 lives by having it, well, you know, as Stalin said, you don't make eggs without an omelet without breaking eggs. And that's a very utilitarian way of looking at the world. I mean, not like it or not, but anyway. But the problem is, if it doesn't do any good, then it can only be justified in terms of justice. And if you look at it in terms of justice, it is manifestly unjust. That is, there are people executed who are not guilty, and there are people executed who may have committed the crime but are nowhere near as guilty as people who are not executed. It is applied in a way that is manifestly unjust and always has. So these are reasons why I am against it. There are also some very complicated reasons why it perdures, why it remains in the United States as against most other Western industrialized countries. And that's a complicated thing that, you know, maybe sometime I'll go into, but there isn't here. So what does one do? Well, when I became a judge, as a practical matter, the areas over which I had jurisdiction did not have it. Connecticut nominally had it, but couldn't apply it for certain reasons. Whether I would have become a federal judge had the death penalty been there, I don't know. The issue wasn't there. Soon after I became a judge, Connecticut changed its law so that it became feasible. New York did the same, and importantly, so did the federal law directly. Vermont, which is part of my jurisdiction, didn't have it, never did. Since then, just recently things have changed. New York abolished it through a brilliant decision of Judith Kaye, the great chief judge of New York, and Connecticut last year, legislatively, abolished it prospectively. There are still some people who are sentenced to death in Connecticut. What will happen to them, we don't know yet. The federal one is still there. But that has meant that I may get some cases on appeal, I'm just an appellate judge, that involve a sentence of death. So what do I do? Well, there are various ways of looking at it. One would be to say, I nullify. I am not true to my oath. I don't think it's right. I will simply say no. I'm not willing to do that. I'm not willing to do that, first, because I've taken an oath to follow the law. Second, because if I did, then other judges who have my view would not be appointed or confirmed. And third, and maybe most important, because I don't trust my fellow judges to nullify that which they don't like. That is, I trust the law more than I do my colleagues, all in all, and I don't want them to feel free to do whatever they want. So that option isn't open to me. Let me distinguish that from the situation of a judge in Nazi Germany or in fascist Italy. Because there, a judge who is proper would be rejecting the whole system. And that judge then has a perfect right to be a revolutionary in a black robe. There's nothing wrong with saying to undercut it. So I hope that if I had been a judge in Nazi Germany or fascist Italy, I would nullify as much as I could. And then probably either get killed or take off. Well, my father was a doctor, but he was a revolutionary in a white robe. And the time came when we had to flee. That's perfectly honorable. But that's not my situation. I don't reject the whole system. I accept the system of the United States. I criticize any number of parts in it, but I don't reject the whole system. I'm not a revolutionary. So that doesn't give me that option there. Some judges in that situation have recused themselves, have said, I feel so strongly about these issues that I cannot be a judge in them. I'm not willing to do that either. If I may use a biblical analogy, I do not want to be Pontius Pilate. Just a second. Sorry. I'm washing my hands of it. I don't want to do it. You guys do it. I don't want to do that because that would leave, as judges in these cases, only those judges who don't have any problem with the death penalty. If judges like me pulled out of those cases, and now as a senior judge I could say I don't want to hear those cases. I'd feel nice and clean, but the judges judging would all be judges who for their own reasons were favorable, or not as unfavorable to it as I. And I don't want to do that. Now, I don't mean to say that that is necessarily wrong. If I were asked as a judge actually to do the execution, I couldn't do it. I'd have to recuse myself. And Justice Potter Stewart, who tried to get the death penalty declared unconstitutional in the United States and failed, made a very good effort, and then it didn't work. After he came back and he had to sit on one case, he retired early. He then died young, but his retirement had nothing to do with that. And I was dean of the Yale Law School. He was a graduate of Yale Law School, so when there was the memorial session of the Supreme Court for him, I was asked to speak. And I said that I thought he had gotten off the court because he couldn't bear to apply the death penalty in that situation. And all of Washington was sort of like this, except his wife, who was sitting right there, and she went like this. And I thought the world of him, so I can understand somebody doing that, recusing themselves, but I can't do that. What is interesting is that there are some judges who have reacted to that in a different way. They have become almost automatons in death penalty cases. Because they opposed it and they couldn't get rid of it, they now say, well, there it is, we applied. There it is, we applied. Justice White, who Stewart tried to do that and failed, became afterwards a total enforcer. Now that's hard to understand. There is historically a very dramatic example of that my great colleague who died young, Robert Cover, wrote about in a book called Justice Accused. It's one of the great books of law, in which he examined the abolitionist judges before the Civil War, who were fiercely abolitionist, anti-slavery, but who as judges were absolutely fierce in enforcing the fugitive slave laws. That when a slave escaped from the South to Massachusetts, they would enforce it and send the person back, even though they were fiercely anti-slavery. And he asked himself, why did they do that? And he looked especially at a judge called Lemuel Shaw, who was a great Chief Justice of Massachusetts, and in many ways a greatly innovative judge, a judge who thought he had much power. He redid all of tort law and contract law in Massachusetts, and he was a fierce abolitionist. Related, I think, to that Major Shaw, who was killed commanding a black regiment in the South, and so on. But when it came to the fugitive slave laws, he enforced them because he felt what? And Cover said this was a kind of cognitive dissonance. They were so opposed that they couldn't stand being the decision maker, and so they convinced themselves that the law was absolutely rigid, so that they were not deciding. They were just an instrument in the hands of the law, la bouche de la loi, the mouth of the law. It was the law and not me speaking. I can't help myself. And there's a very interesting literary fact about this, because Lemuel Shaw, this isn't something many people know. I found it out and then Cover found it and put it in his book. Lemuel Shaw had a son-in-law who was greater than he was. He was the great writer Melville, from Melville, Moby Dick and all those things. And he was very close to his son-in-law and his son-in-law to him. Shaw supported him, helped him in writing and so on. And Melville wrote a short story called Billy Budd, in which a captain, whose name is Captain Vere, V-E-R-E, Truth, has to execute his beloved seaman, because the seaman punches an officer, provoked by that officer, and can do no other. And Melville is asking, how can this be, the great writer, asking about his father-in-law? How can he do that? Well, that happens too. But of course, that is not something that I will allow myself to do. Indeed, if I were inclined to do that, then I might just as well recuse myself and get off. And because I become a judge, if I do that, who is more than the judge who is pro the death penalty. So what do I do? Well, I use, Thomas More said, God gave us brains to avoid martyrdom. Ultimately, he became a martyr. He couldn't get out of it. But the idea was to use all the brains you were given to try to avoid that situation. So what do I do when there is a death penalty case, or any case where the law seems to be wrong and immoral? I wake up in the middle of the night to try to see if that is really the law, or if there's some way that is consistent with the law that allows me to come out right. And I use all the brains God gave me to try to do it. And when I come up with something, I then come into conference the next day and say to the other judges, you know, we all thought that this case should come this way, but actually, for these and these reasons, it ought to come out the other way. And since our court is not a particularly ideological court, when that happens, usually one or both of the other judges will say, oh good, Guido, this case was bothering me too. I'm so glad you found a way. But of course it wasn't bothering them as much as it bothered me, otherwise they would have stayed up in the middle of the night. But that advances the law in the right way, as well as comes out with a right result. These other judges will have their own cases where they do that and wake up in the middle of the night. And by the way, if you do that and you come out right, because of that, the next night you sleep very well. You sleep very well. And when I say wake up in the middle of the night, that's a metaphor. In an ordinary case, that may be what happens. If I see a capital case coming, that may come to me, or may not, I start looking at it from the moment it starts to see if a mistake is being made anywhere along the line that will allow me, consistent with the law, to avoid capital punishment. And there was one famous case in which I found something. As it happened, the jury ultimately did not give capital punishment. And I said to the judge below, who was a very famous judge who had written the book, you know, you made a mistake in this case. And he said, what? And I said to him, here, this, and this. It didn't matter because of the way the jury came out. And he said, good heavens, you're right. You know. So, you do that. And so far, I have not had to enforce any case of capital punishment. I know now that I am sitting on a panel that will hear, because our procedure is such that when a capital case reaches a certain level, a panel of judges is appointed long before it comes, so that all the motions, everything comes, and it will come to us, and it will come to so on. I know that I am sitting on a case with two very difficult judges, one especially. Of a very conservative woman, brilliant, very, very, very conservative, of a family that comes from Lucca, and I keep telling her, Lucca never had capital punishment, that it doesn't do it good. And it will come to me at some point, and we'll see. We'll see. As I say, so far, I've not been able to. What happens if ultimately a case comes and I'm not able to find a way? Well, I think then what you do is write a concurring opinion. It is a separate opinion which says, this is terribly wrong, but I am compelled by the law to go along. And you write for history on why this law is so wrong. And you feel very good. Because, and you know, I've had it in some cases, not capital punishment cases, but a case about campaign financing, the Supreme Court's absurd decisions that you can't control the amount of campaign financing. There was a wonderful opinion in a case called Ogni Bene, which says the Supreme Court is crazy, and here's why, and history will come out my way, and I'm good, and I'm lovely, and so on. And that's a great deal of fun when you write for history, because you're liberated from what the law is, and you go back to first principles. Not liberated from first principles of law, you're liberated from stare decisis, or, you know, and you write this wonderful thing, and so on, and you feel very good about it. The problem with that is that while it makes you feel good, and it may be the best that you can do, in one way, if you end up doing that, you have failed. It means you have not been able to come out right in the individual case. And since it feels so good to write the great concurring opinion to history, there is a temptation to not look that far and write that great thing which says how good and true I am, And you people are doing terrible things. T.S. Eliot, who is a writer I don't like because he was a nasty man, brilliant poet, but a nasty person, in Murder in the Cathedral, spoke of a temptation to martyrdom, of a desire to become a martyr. And when you write this kind of opinion, that's the kind of thing. Look how sad it is that I have to go along with this. But that's a temptation that's particularly great, because in the true martyrdom, you're the martyr. Here, the person who gets it in the neck is the victim, is the person who gets executed. You're just a poor judge who has to do that. So it's a rather nice martyrdom. So that's something that you have to avoid and do everything you can to keep from being in that situation. It may be that that's the best that you can do. And if that happens, then that is what I will do. I hope I die before, and I hope to live a good long time, but I hope I die before I find myself in that situation. But that is what you would do. But one thing you cannot do, if you are in that situation, is ask the person whom you are not saving to forgive you. You know? Then it is between you and your God. But you can't ask the person whom you have not been able to keep from this injustice to say, oh, it's all right. Oh, it's all right. And I have two stories on that. One involves some vulgar language, which you'll excuse me for. One of my teachers, who was a Pollock, my teacher of constitutional law, became a federal district judge in Pennsylvania later on. He'd been dean and he went there. And he was a very sweet, nice man. He told the story of himself. But when he became a judge, he had to sentence somebody to a sentence which he thought was unjustly long, and he couldn't do anything about it. And when he had finished sentencing, he got off a bench and he went up to the man and he said, I can't tell you how sorry I am. To which the man looked at him and said, fuck you! Which was exactly the right thing to say. I mean, you know, you want me to, I'm the one who's going to jail, and you want me to tell you it's all right, kid? No, you can't do that. It is between you. Okay. The other story is an interesting one. It is in a way still going on about decisions of this sort. Many years ago, but almost 30 years ago now, 27, 30 years ago now, I was on a panel, I was presiding, and it was a case of habeas corpus in which a youngster had been sentenced to life in prison for murdering his parents. And he was claiming that there were all sorts of things, that he was innocent, and that there were all sorts of things done that were wrong in the trial. Now, you know, we get many cases of habeas corpus in which some things were done which were wrong, and which we reversed for that reason, but in which basically you think the person was guilty. There was something about that case that smelled. A whole series of things. The police had behaved very badly. They had lied to this guy. He was a kid, 17, 18 years old, and so on. And any number of things had happened that made me think that this guy might actually be innocent. And fairly likely because of the things. I went into conference and I said that. And the other two judges, both of whom had long experienced as federal district judges, as trial judges, said, that's all very well, Guido, but you cannot, on the law, grant habeas in this case. You just can't do it. Now, one of these judges, who's still there and is very conservative, a guy named Jose Cabranes, I might have said, well, you know, this guy would send anybody to jail if he could, so I don't really think much. The other, a man named Fred Parker, who died young, after looking out the window when 9/11 happened. Our building was right nearby. I sat a week before, so I was back in New Haven. He was there. He saw everything that happened, and he never recovered from it. He had a heart attack long after. It was such a shocking thing to see that happen. He was a very sweet man and a very good judge. Slow, but probably changed my mind more than any other judges because he ground exceeding time. He said, you just can't do it. So I went along rather than dissenting. Useless to dissent anyway because the two were going to come out that way, I thought. And I wrote an opinion which was narrow, which also created one way which I thought would lead to a new trial. And I got them to go along with that. But it didn't, ultimately. So the guy stayed in jail. And then, over time, more and more evidence that this guy was not guilty started developing. And he kept going back to the state courts to say, look, here's more evidence. And the state courts at that point said, oh, you know, you can convicted, finality, and all that stuff again and again and again. And I got more and more nervous because I kept saying to myself, you know, maybe if I had dissented and said, this is one of those rare cases that smells to me, the state court might pay more attention to what this guy is saying. And I got sufficiently troubled by this that I asked the great chief judge of our court, who is a friend of mine, same age, had different careers, but is sort of a conscience of our court, can I write the state judges and tell them that? And he said, no, you as an individual are not allowed to. Your panel could. But by then, Fred Parker had died and Cabranes didn't want to. So we couldn't, and I got more and more nervous. And this became a kind of object lesson to my law clerks. I told my law clerks, but you know, it may seem that it isn't worthwhile dissenting sometimes when it's going to be the same way, and it's better for you to write a narrow opinion rather than being on the other side, in which case Cabranes would have written the opinion and would have written a much broader opinion about why what the prosecution did and the police did was perfectly right, which I wouldn't have wanted, but there are times when you should dissent anyway, despite that and so on. And then it happened that one of my clerks, his name was Roberto Gonzalez, a wonderful kid whose family were originally illegal immigrants from Mexico into the south of the United States, and were, like so many immigrants, are a source of what has made America at its best, if you call this guy, went to work for a big law firm in New York for a while, and found that this guy, still in jail, had asked whether they would take on his case pro bono. And he knew about it, and he convinced them to take it on, and he became the lawyer in it. And by then, the evidence was so strong that he actually got the conviction quashed. 17 years after this person had been sentenced. He'd been in jail for 17 years. At this point, the guy, whose name is Marty Tancliffe, was released, and Roberto said to him, do you want to meet the judge who wrote the opinion denying you habeas? Wow. And this guy said, yeah, I'd love to meet her. Oh, no. I understand. So Roberto got him to meet me, and we had a very good conversation. We talked about what he wanted to do. He wanted to go back to school, and then he wanted to go to law school. And he has indeed. He graduates from Truro Law School this spring, I went down and judged his moot court trial for him. He is going to be involved as a lawyer in defending people who have been jailed and who think it is they were innocent. And I think he'll be able to afford it because just last week, the state of New York has settled his claim that the state prosecutors had behaved badly for $3.5 million. So he'll be able to afford doing that. So sometime you can have that relationship, but that's a very unusual, most of the time. It's a very long answer, but the question, as you can see, is one which I think any judge worth her salt has to focus on all the time. It is, by the way, the thing that makes being a judge ultimately most satisfying. You know? I'm a teacher. That's my job. That's what I've done most of my life. I turned down a judgeship when I was very young because it would have been a trial judge, double district judge, and I couldn't have done that and teach and write, and I've always wanted to. In my dotage, because I was already in my 60s, 20 years ago, President Clinton decided to make me a judge. He'd been a student at Yale, he knew me, and he wanted to make me a judge. So I said yes, not really knowing what I was in for, because if a president of the United States asks you to do something which you can do and which is honorable, and you're a refugee and an immigrant, that is, you're a patriot, a criticizing patriot, because I criticize all sorts of things, you don't say no. So I did it. I found it's wonderful, and I was able to do that and still teach, which I do. And I've asked myself, what is it that I like about being a judge? Every once in a while, you get to write the great opinion that gets put in the case books that you guys study and so on. And that's, of course, nice. And then have people you respect write you a letter, Posner, about an opinion which dealt with 2 of my books that I wrote, and said, that's Guido at his best. And I said, yeah, that's nice. But after all, you can do the same thing by writing articles. I mean, if you're doing something which moves the law and that, yeah, writing the opinion. So that's fun, but that's not. And then there are all the relatively easy cases where you try to write something that is elegant and right and don't have much to them intellectually, but which are fun because when you look at these cases, which are easy, you then change the facts slightly in your mind to think about what you would do if the case was difficult. And that makes them fun while you're dealing with them. And it also enables you to be a judge who is a generalist, because the first time an issue I know nothing about comes up, it's in an easy case. And even I can deal with an issue I know nothing about if it's easy, if the law is quite clear. But I play with it and start making it more difficult, so that by the time I get a case in that area which is difficult, I know enough about it to deal with it. So that's fine. But that isn't what makes it. What makes it fun, really interesting to be a judge, is precisely the cases where the law seems wrong. Because there is where you can make a difference. And there, if you use the brains God gave you, you can turn it around and make it right. And that's something you can't do as a teacher or as anything else. So it's that which gives real satisfaction. Those nights when you can go back home and sleep well. Because you have done something which had you not been there and woken up the night before and used all your brains and your power to convince, the others would not have been. So that's what makes me a judge. I think probably, yeah, it's after 12, so let's call it a day. Thank you. Tomorrow I'll be talking about values of law and economics.